Morning, Board.
Morning.
All right, good to see everyone. The judge, as I stated earlier, he may call in. If he does, then we'll stop, read the statement of necessity, and at that point, we'll do a roll call vote from henceforward. But instead of waiting on him, since we have quorum, we can go on and get started with business. Unless there's any opening comments, does anyone have anything they'd like to say or to greet us? Or if not, I will just jump right in. All right.
Call this meeting to order. It is 9:06 a.m. on Friday, September 28, 2018. This is the Tennessee Board of Court Reporting, and I will ask the Director to call the roll, please.
Yes, sir. Thank you, Chair. Britt Collins.
Present.
Ken Gibson.
Present.
John Rambo. Marilyn Morgan.
Present.
Ken Mansfield.
Present.
Earl Houston.
Present.
Thank you, Chair. We have quorum.
Please read in the notice of meeting, please.
Yes, sir. Notice of September 28, 2018, meeting of the Court Reporters Board was posted to the Court Reporters Board website September 13th, 2018.
Okay. Next, we will review and approve the agenda for today's meeting. Do we need to read that in?
No, sir. It'll be a matter of record,
Okay.
So it's fine.
Okay. Does anybody have any recommended changes to the agenda for today's meeting?
I don't. I move we accept the agenda.
Is there a second?
Second.
Okay. Do we just do that by voice vote?
That'll be fine. Yes, sir.
Okay. All in favor?
Aye.
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 Okay. Any opposed? Okay. The motion to approve the agenda as printed passes by unanimous voice vote.
For the March minutes then, has everyone had an opportunity to look at those? Are there any edits or comments or anything in that regard?
I did notice that the minutes that we have here, the first sentence there says that the meeting was on September 23rd, 2018. That needs to be changed to March 23rd, 2018.
Okay, great. We can do that.
They note anything else? I think from my perspective, everything else looked accurate.
Okay, unless there's any comments, do we have a motion in that regard to accept them with the edit as suggested?
Make a motion we accept them with the correction to March 23rd, 2018.
Is there a second?
Second.
Okay, all in favor?
Aye.
Aye.
Aye. Any opposed? Okay, the motion to approve the minutes as written with the exception of an edit to change September 23rd, 2018 to March 23rd, 2018 passes by unanimous voice vote.
Thank you, Chair.
I can now recognize the Director for the Director's report.
Thank you, Chair. We'll just start first with the budget as enumerated there. This will just be for informational purposes, nothing actionable on this, but always good to know where we stand fiscally. So we're going to start with kind of the snapshot and then drill down to the particulars. So we've got last year's fiscal year in. As you see, we had a reserve balance of $143,000 roughly. If we move to the entire year, the trend analysis there, you'll note that we ended with a net, let's see, it looks like a net deficit of about $9,000, well, close to $10,000. Primarily that was because the fact that we had the core expense. We knew that was coming. We've been talking about that for last couple meetings, matter of fact. So that was actually debited there, you'll see on May. At the very top of Edison expenditures, one of those line items was the core expense. So the majority share of that would be that one-time expense. You won't see expense like that again unless there's ever a project to this magnitude, but nothing foreseen or on the horizon. So, with the reserve budget of about 143, and we're taking a net deficit this fiscal year of about 10,000. We're in pretty good fiscal health, so we're not too concerned about that. It doesn't look like there's no anomalies or anything outside the ordinary. You will notice that the revenue on May 18th and May 19th starts to uptick a little bit, and if you go to the next, the beginning of this fiscal year, it kind of tapers off to 19,000. That would be your renewal cycle. That's everyone's is renewing this. We're required to do so by the end of June, so that's where that's coming from. It's starting to pick up, and then of course the robust return on June, the very month that we're going to be that's required. So that's what you're looking at there. As far as, and while we're there, great segue to talk about the renewals themselves.
Ask a question
Yes, sir.
real quick on with the core system. Do we have any expectation of what the ongoing expense is going to be? I mean, is there? I know we're not going to get $40,000, $50,000, $60,000 charges again, but is there like a monthly maintenance fee or a chargeback that we're going to see just for our budgeting purposes going forward?
What you're looking at is administrative cost backs. Administrative cost backs are just everything that's shared expenses for all the programs. You're looking at, and that's based on licensing count, which we have I think like 458 licensing counts, so pretty relatively low. Let me see the numbers on that. 448. So that number of complaints, which if you saw legal reports, kind of low, and then just the budget report. The last expenditure of admin cost backs on the first itemized, I think it's page 2, you'll see a credit of $834. That's reassessed every single fiscal year. So at the end of the fiscal year, they realized, okay, well, the expenses for total or projected for this program was a little lower than anticipated. So then they're crediting it back to the program. But you're looking at the shared administrative expenses, and actually we're seeing some efficiency. So we actually expect that to be lower because we're all sharing, tenants in the same building. We're reaping some of the rewards of AWS since we won't have as big of a footprint facility-wise. Technology, we're all sharing the same IT experts. So we expect actually more efficiencies rather than expense.
Great.
Unless there's any more questions on the budget, I'd like to go and give you kind of just a snapshot of a report of this renewal cycle. There was 448 out of 512 reporters that renewed, which amounts to close to 90%, about 88 exact, of those that actually renewed, 64 in expired grace. Now, those folks, of course, have been notified. Some of those folks just may be retirements. So some of those folks may have just decided that for whatever reason not to renew. So we'll track those, but pretty robust return. That's not bad, not right at 90%. So we feel pretty good about that. And we talked about a quarterly CE audit. We've had that discussion, and instead of everyone submitting their CE, they submit all their CEs, but we don't actually do a 100% audit. We agreed on a 10% quarterly audit. That'll actually begin this first quarter. So the end of next month, we'll pull about 10%, and that'll be roughly 50. And then we'll audit all of their CEs submitted for that renewal cycle. And we'll continue to do that every quarter. So, and without repeating the same group. So eventually everybody will get audited. But it is randomized, and we hope to do it in such a way that we're not doing the same folks over and over and over again. So we'll have to work that out without giving too much inside baseball. But for the most part, we're working it out where we can capture the lion's share of the licensee pool, but at the same time too, not hit the over again, or giving anyone a sense of confidence that just because I got audited this cycle, I'm okay the next couple cycles either. So, kind of working out the particulars of that. But nonetheless, we'll do that at the end of next month.
Part of the renewal process, do y'all get any sort of feedback as to why people aren't renewing?
And not much besides associations. That's where we get I think the heart of that kind of feedback. The associations and their representatives as they reach out to us, and we're thankful for that. Initially there was some adjustment. We saw it was slow to kind of enter into that new environment, but then it really an uptick right towards the end of June, and then thereafter, it seems like everyone's made that adjustment. So we haven't seen things as a result to process. So we can't quite put our finger on that piece. Now, if this becomes a trend next renewal cycle, then we'll have to look at that a little more deeply. But right at 90%, we feel pretty good. But we're going to see what happens in expired grace, too, if somewhere along the next few months they pick it up and then decide to keep their license or not.
I think there's just been a concern kind of ongoing, which is not anything that we can really do anything about, but just general decline in the number of reporters, and that just being bad for the system in general. And so just curious if y'all knew why that was, other than, everybody's getting jobs doing other stuff.
We don't. It's very anecdotal. I wish I had something where I could say the lion's share is saying this, and then we could really kind of wrap our hands around that. But much like any discussions when we're trying to postulate what that could be, it's nothing substantive to really tell us one way or the other. But like you said, I would love to see what happens at the next renewal cycle too, to see if we keep our 448 or if we lose another however many, then that would be, in my mind, would be problematic then.
We're down 20 or 25% probably from a couple of years, aren't we, at around 600 or
We
so
were close to
at one
700
point?
at one time.
Yeah, so, a really dramatic decrease.
Reporters are retiring and new reporters aren't coming in is the problem.
And a lot of reporters who were official reporters at one time have left the state to go to states where they still hire official reporters.
Well, and it's not just unique to court reporters. We've seen some with our other programs as well. Like Land Surveyor, for example, they're really heavily recruiting right now. We've seen a pretty sustained decline in that licensee-ship as well. And so they're really out there, hitting the boards pretty hard, trying to get the message out, starting with, and starting early. I've seen they've got programs for high schoolers, where they're trying to, cultivate that interest early. Let them know that this is a, viable profession, a respected profession, and something that you may be interested in. It's not, something that you don't really know about until you get later. There's some licensed professions here that I wasn't much aware of either. And had I known, maybe my college path would have been different. So I think it's just giving them the information and getting that out there is really helpful.
Now, is anybody aware of any? It seems like I don't know if I was talking to someone or if
Yes,
Well, some people say yes, some people say no.
maybe nationwide, I'll put it that way.
There's probably shortages in certain areas, probably so.
so that could account for the decline in the sense that
Frankly, there's not as much work for reporters as there used to be a decade ago either. Workers' comp, as we know, has really changed over the years, and there used to be a workers' comp venue, and there's hardly any anymore.
And there's shortages across in a lot of professions, and another one would be land surveyor as well because of retirements. They're seeing, their license sheet just getting ate up by retirements. My brother-in-law is air traffic controller. Well, when Reagan fired everybody, all those folks are retiring. They all came in one big wave, and so that's probably Judge Rambo there. Hello, Judge.
Hey, good morning.
Good morning. Welcome aboard. We're just moving our way down the agenda. We're at the budget report now. We're having a discussion about the licensing pool. Our licensing pool sits at 448, so we're just having discussions about, we lost about, 64. Their Inspire Grace failed to renew in this cycle, so we're just having a discussion about why that might be and trying to head that off if it is a decline.
Thank you.
And the National Court Reporters Association and TCRA we have an A to Z program. Have you heard of that? It's a free, 8-week class to gauge interest in the profession because it's hard. It's difficult to pass. And we're also working nationwide now on trying to recruit military spouses into the profession. And if they can get funding for that, that'll be a good way to bring more reporters in.
And so I think it's not just this profession. I think it's a lot of professions. Pilots too. They're having a hard time getting pilots over there, and They're given all kinds of incentives to include, looking for funding and grants to kind of boost that interest and make it possible for people to transition that too. There's a lot of internships I had to pass up early in college because I was working my way through college. I had an opportunity where I didn't have to pay rent and, pay for school at the same time. Maybe I would have done some of those internships. So things like what you're talking about are really helpful. So I'm glad that's in play.
Can I ask you to clarify one thing about renewal? It came to my attention through the association, and I emailed you about it, that there's, I guess it's a rumor, that the board had given people until December 31st to renew, that they had an extension. And I know you said that's not the case, so I wonder if you might tell us what they have until December 31st to do, if anything.
I'd have to look at that email again.
Okay, if their license lapsed, I think what it says is they can't report as of June, whatever the day is, July 1, but they have until December 31st to come up with their
okay.
CEUs to get it reinstated.
Thank you. That's expired grace.
Expired
That's what
grace.
you're talking
Okay.
about. These reporters are in expired grace, meaning they don't have to go through all their training again. They can't report, but they have until they have 1 year that they can submit those Cs and then pay whatever fees, penalties to get reinstated or to get renewed. But expired grace doesn't mean it's not that they can continue to operate under an active license, because it's not active. It's expired grace. It's just some programs do allow a grace period for your renewals, whereas others it's expired, and then that automatically triggers reapplication. And a reapplication means you got to take the course over again, all the resubmit as if you're brand new, have never touched the board before. So that's not the case. They have 1 year to get their Cs, pay their penalties, and then they would be renewed immediately. So thank you for jogging my memory there. I was trying to find that. Okay, unless there's any other questions, I'll tell you what, since we've got Judge Rambo on the phone, let me read the statement of necessity, and then from here forth, any actionable items, we'll do a roll call vote. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by a governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting for the Tennessee Board of Court Reporting, and the purpose of today's meeting with one member attending by teleconference is to discuss the agenda as noticed on the website earlier. If I can have a motion to accept that statement, then we'll move on from there. Do we have a motion in that regard?
I'll make it.
All right, thank you, Judge. So that we have a second.
I'll second.
Call the roll.
Thanks, sir. Mr. Collins?
Aye.
Mr. Gibson?
Aye.
Judge Rambo?
Aye.
Miss Morgan?
Aye.
Mr. Mansfield?
Aye.
Mr. Houston? Aye. All right. Thank you. It passes by roll call vote. All right. The anonymous complaints. Let me jog everyone's memory why this is on there. It's been, lots happened. You've done a lot of reports, or been in your particular practice, conducting a lot of business since our last meeting. So let me just kind of give you brush up your memory there. There was, at our last meeting, the board wanted a policy on anonymous complaints. There was wanted a SOP. That's provided here. That was already done. That was some time ago. It was signed, it looks like last year. So page 3 shows you what that policy is. It's highlighted there, that paragraph, that first paragraph under opening a complaint. And so the short of the long is this. In the past, anything that met that criteria under that SOP as articulated in the SOP wasn't even referred to the board. There wasn't anything to go on, nothing to refer, really was what it comes down to. And so just a matter of practice, those just weren't referred. What we want to do now is to open those complaints and then close them for tracking purposes only. So we're still, not referring them, but we kind of are once, if we're going to open it. If you open it, it's a referral. And so it's really a matter of process. So that would be our SOP. That's not going to change. But if we open it and it's been referred to the board, only the board can grant authority to close it at that point. So that's what we're asking for, administrative authority, just to close those complaints only that meet that criteria. So that's why we're here today, in regard, or at least that's why that's here today. Any comments or questions about that?
So who is it that's doing the review?
It's done in conjunction with our staff attorneys. It starts with complaints team, and primarily that would be the executive director over complaints, and along with her admin manager in conjunction with the staff attorney. So if there's nothing for them, and then they're also working with other programs that have this same process in play. So you get an idea, if you've got nothing you don't have anything to call back on, or a name or anything, then there's nothing, there's no particulars for it to follow up on. Those just get closed, and they don't refer those to other programs, but we like to, with all of our programs, continue.
Will those be presented to us in the form of a new case? Like
They wouldn't be, they would, like before, they would never be referred.
They won't even appear on the legal report,
That's correct.
despite the fact that the file's open.
It would be closed administratively if
Okay.
the board granted that on those complaints only.
So what we've got in here in these procedures that the regulatory board's complaint handling SOP, that you've got a procedure in here for staff to just decline to open a complaint.
Sure.
Why are we drawing a distinction on anonymous and non-anonymous complaints that either, whether it's anonymous or not, it either states a potential violation or it doesn't. And if it does, then it goes up the chain to be reviewed further. And if it doesn't, then a file wouldn't be opened. But why are we treating the anonymous complaints differently and opening a file and then immediately closing it, when on a non-anonymous complaint that doesn't state a violation or potentially state a violation, we never even open a file?
I think, and maybe the word anonymous, and I have to use that word because it's here, anonymous complaints, assumes that one part of the complaint is anonymous. Here, it's both parts, because if if you read it says what it includes but not limited to, it says respondent contact information. So that's one part to it, but also the allegations of violations and/or supporting documentation. What they're alleging is just some random, crazy sort of, not even associated to the board. Well, we didn't want to tie up resources for something that's not even, maybe even pertinent to what our scope of jurisdiction would even be. Those are the type of complaints we're talking about.
The complaints that usually will come to me for review, they are often something that is outside of the board's jurisdiction to even rule on. In the alternative, there's something that we don't have enough information. So if we receive an anonymous complaint and we can't go back to that person to ask them for more information, there's nowhere to go from there, really.
It would be something like, I'm just going to pull to kind of give you an idea of what I'm talking about. It would be something like, I think there might be, something going on in a courtroom in Tennessee. See what I mean? It's like there's nothing to do with that. You couldn't do anything with that information. And so to open that and to send it up to an attorney to investigate that and to assign it to an investigator for to go through the motions when ultimately you know where that's going to end.
There's no way, in that case, there's nowhere to assign the investigation, nowhere to begin. So in that case, rather than leaving it open to bring to you all to tell us to close it because we don't have enough information, should the board so choose, we can administratively close that and move on to the other cases where there is enough information for investigation.
This is really about trying to cut out one step in the process, which is that it never comes to you.
So they still need approval from legal to close it, and I usually will
Okay.
tell them there is not enough information or it's outside of the board's jurisdiction. If those questions, if I feel like there's enough information, if I feel like it is something that the board needs to see, we will continue on in the process. But if
Okay.
it's clear from the complaint that there's nothing that can be done from our side, I would tell Centralized to go ahead and close those complaints.
So it's not purely just a staff administrative decision. There is going to be council review of all of them, regardless of whether it's anonymous or not.
There is.
Okay.
Yeah, I think what they're saying is your office makes that decision,
And
not just a staff member of the office.
That's right. That's right. It is. Those type of things are referred to their immediate line. So it won't be somebody like in a call center, a new hire in a call center who just receives it and like, this doesn't need to be referred, or it's not worth their attention. That's not how that would work. They would require a decision from that program and their leadership for them to make that determination based on whether they see anything actionable. And if there's anything actionable, then they'll refer it. But there's nothing actionable about it, then, we still we haven't been referring it anyway, but, we want to start keeping those metrics too. So they want that data. So to do that, we need to open it so we can track it in our system.
There's some action we need to take today on this?
There
Are you just informing us that this is what's happening, or do we have to do something?
No, we would need authority from the board to close those administratively, just those ones that we haven't been referring. We're going to open those and then close those. But we're going to put it in our system and then close it, not actionable, anonymous, that sort of thing. But then that's a metric now that we can track. Whereas before, when they're not getting referred, we're not tracking those metrics. And so that's kind of what we want. So actually, it's more disclosure, than what we had before, because before we're not putting that in the system. We're not opening and closing it. Whereas now we are.
You're making a record of those anonymous complaints,
That's right. But within
but you're not taking any action.
That's right.
On them based on the content of the complaint.
Delegate.
yes, sir. That's correct.
Okay. Somebody want to make a motion?
I move that we accept
Second.
Executive Director, call the roll, please.
Thanks, Chair. Mr. Collins,
Aye.
Mr. Gibson,
Aye.
Judge Rambo,
Aye.
Miss Morgan, Mr. Mansfield,
Aye.
and Mr. Houston.
Aye.
All right, thank you. We can move to the meeting dates. I trust you had an opportunity to look at those. We basically just mirrored the meeting dates that we have each year. Thank you. And so we did 2 meetings scheduled, same mirrored as the last couple years. So it'll be that last Friday of both of those months at the same time, 9 o'clock in this room. Does that work for everybody? Is there any comments or?
Not me.
If that works, then if I could have a motion in that regard, that would be
I
helpful.
move we accept the dates suggested.
Second that motion.
Please call the roll.
Mr. Collins,
Aye.
Mr. Gibson,
Aye.
Judge Rambo,
Aye.
Miss Morgan,
Aye.
Mr. Mansfield,
Aye.
and Mr. Houston.
Aye.
All right, thank you very much. That gets us to our legal report.
Good morning, board members. My name is Shalina Brown, and I'm here on behalf of the legal division, and with me is Dennis Gregory, and there are no new cases to present to you today. However, we do have 2 cases that we'd like to represent to you for consideration.
Case number 1, it's listed as 2017-13. I'm not sure if the board prefers I summarize. This is a case that was originally opened prior to the previous board meeting, and you'll note the previous recommendation was to defer the decision pending an investigation. So we actually did send an investigator out to you'll see the new information. Again, if you have any questions, the recommendation, however, is to close the complaint based on the new information.
I was bothered by this one. And maybe you all who've been involved in the investigation of this can shed some light on it, but it sounds like this is just a very defiant respondent
It could be.
who seems to be thumbing her nose. And what we're supposed to do is enforce the statute and the regulations, and we've got someone here who's saying, I'm unwilling to sign a consent order, and I'm continuing on doing what I'm doing, which, if we look at the allegations that are in the report that we have here, seem to support a violation of the statute and the regulations. And the justification for not moving forward is she's maybe a sick old lady, and the two ladies who, I'm assuming, I shouldn't have assumed they were women, but the two complainants maybe now feel sorry for her and don't want to move forward. That to me doesn't seem like a justification for not enforcing the rules and regulations.
I would agree with that wholeheartedly. Apparently, reading between the lines, it sounds like this particular person thinks they can just use their notary seal and that's sufficient. And that is not sufficient under the current state of the law.
Is this person reporting, or are the quote girls reporting?
The girls are doing the transcribing,
Yeah, but
the
are they,
reporting.
Are they licensed? Do
No.
we have any information?
No.
So they're just a couple random
Who can type?
girls.
that's a typist, not a court reporter.
Correct.
And the 84-year-old lady does not have a license?
She did, but it's now elapsed, so she's effectively unlicensed.
That's why I asked, is she reporting? Is she going out with her rider? And
As far as I know, she's not doing anything. She's not reporting.
so the girls are effectively reporting without a license.
Correct.
Yeah.
Sorry. I have two concerns about this issue. First is that at that point, from that point, I think it doesn't matter that the complainants withdrew. The allegation has still been made, which we have to proceed on, regardless to whether they're involved at this point or not, because the allegation has been proven to be accurate, right? All right, so that's number one. And then number two is we do not need for this to be reviewed actor in this case. And on its face, that's what it appears, even though I know that's not the case. That's what we could get the impression that that is the case. So I think we probably need to reassess this one and figure out.
I have a question. Is there, we have to consider the public here as well. Is there any harm done, let's say, when an unlicensed court reporter does a court transcript and that goes up to the Court of Appeals, it's a transcript prepared by an unlicensed court reporter. Is that has that done harm to the public in any way? Can that be objected to?
It could do harm to the public.
The whole idea of the licensure law was to protect the public, was one of its goals, is to make sure you have a competent court reporter. And that's the competency is illustrated by the licensing. And I just don't think that we can let this stand.
I think we have to be careful with this one from the standpoint that I don't think there's an allegation that the transcript effective or damaged in any way. Orders. I think we just have to deal with the sole issue that they were engaging in the act of court reporting as unlicensed reporters. hasn't been any allegation past that. We don't want to jump the gun, I don't think, here. So I think we just need to deal with the issue of the violation at hand, and we need to make sure that we follow through.
It's as if the reporter is she's really running a firm in which no one is licensed. So, I mean, it's a little more egregious than just based on these allegations. Of course, they could turn out to not be true, but that allegation suggests she's operating a court reporting firm with multiple people and nobody in it is licensed, nobody's subject to regulation, nobody's kept up education. It's more than just one person doing one thing, and again, the kind of defiance of the whole system is the part that bothers me maybe more than anything.
According to our regulations, the reporter has to attach a certificate with her license number on it, not a notary seal.
And the expiration.
Yeah.
The question for the board is, I guess, can we order her to stop the practice as an unlicensed reporter, number one. And number two.
Well, we'd have to have an administrative hearing.
Well, not necessarily. We could send the consent order. The original recommendation was actually to forward the unlicensed individual a $100 consent order with a $100 civil penalty as part of that consent order. So we could still do that. We could be more than that. It could be less. You're right. If it was a refusal to sign the consent order, then we would be at the formal hearing stage.
I think if we give a $100 fine, a person might think that they can just continue to practice and just pay $100 every time it comes up and save a little money. I just don't see that that's an appropriate fine.
The consent order, does it always have language in it that where they agree to stop what the violative conduct is? What, from a practical standpoint, what's the enforcement mechanism for that?
There is none.
Can an injunction be filed?
Do we have authority to initiate legal proceedings?
I think only the Attorney General's office would have that authority, which, I mean, I guess the question would then become, would they accept, they would be effectively taking our case. I mean, our cases from a reg board standpoint do go to the Attorney General's office when they're appealed. And if this individual were to appeal the results of a formal hearing, then I think an injunction would become part of the math.
I think you're right, Dennis. I think it would be, we would refer the case to the Attorney General's office to get that injunction.
I agree.
Isn't there a provision that isn't it a misdemeanor, a class?
Is there any indication thus far that, because this complaint is probably close to a year old, maybe longer, any indication that she's stopped doing this during the course of this investigation, or is she continuing on?
Where our investigator returned the report, it appeared that they had not ceased, or she had not ceased. And it's not in the new information summary, but to give you a little more background about the complainants, they opted to say withdraw. They wanted to remove themselves from the complaint, I guess is the best way to put it, because it would be bad for business. Again, that should impact your decision, but just to give you a little more background about the complaints. And in terms of civil penalties, Ms. Brown actually just brought to my attention there is a civil penalty not to exceed $500 for unlicensed activity. So,
Per activity. There could be several.
It could be, right.
I think this horse is out of the barn.
I think we should
I
attempt
think we
the
need to go
consent
with-
order. I think we should raise the civil penalty to $500. And if she doesn't sign it, then we proceed from there. lay the groundwork for the AG's office at that point.
I mean, the most we can do, even if we have an administrative hearing, is assess $500, obviously, per magnet. I understand that there could be 20, and so we, but if there's only one proven, 500 is the most that we can do in any case. So, I mean, she would be willing to sign that and pay that, then that's as good as we're going to likely get after going through all the time and expense of an administrative hearing.
And one of the reasons that I think the board opted back in March to have an investigator go out and interview folks was that there was an allegation there were thousands of transcripts, and we didn't really know what thousands meant. I mean, was it 1,000? Was it 10,000? So,
But I think I need to understand how the appeal process works. From our hearing, if it was referred up to the AG's office,
they would have they would have the record. I mean, the AG's office would simply just take the record that was done. Also becomes a chancery court matter. The rules of civil procedure do apply even in our reg board hearings to an extent, but there you have, it's full. So,
And as far as timing, is there a way to expedite this so we don't kick the can down the road another 6 months?
Well, as soon as, we adjourn here today, I mean, I could have a consent order probably in the mail by the end of next week going to this individual. We usually allow them 30 days to mull it over, either, by themselves or with an attorney or whatever. And then usually a last chance letter is sent out sometime after the expiration of the 30 days. The only way to have, if there was a declination of the consent order and a desire for the person to have the formal hearing, I believe because it's unlicensed activity, and correct me if I'm wrong, this could be heard by an ALJ alone or does...
That's correct. So in the interim, if we decide to go to a formal hearing prior to the next board meeting, we could present this to an ALJ sitting alone.
Okay, so we wouldn't have to be there. Okay.
Exactly.
I may have missed out on some of the background on this, but since firms are not licensed in Tennessee, why are we not going after the, quote, girls who are doing the reporting and typing and have no license?
I think that's probably just a matter of Dennis going on what the board authorized at the last meeting. They wanted an investigation on that. The board can also, issue a civil penalty to this named respondent and then establish complaints against the other two. That's something that you all do have the authority to do.
I'm sorry.
No.
Go ahead, please.
I was just going to say there's no complaint against the other two.
Yeah, do we have authority to initiate our own investigations
Based on
without
the
a
information
complaint?
he's giving you, yes.
Of course, we don't know who they are, but
Right, that's
maybe
the issue.
y'all do, or the investigator might.
Investigator could find out, right?
That's what concerns me, is that we can't really go after firms. What she's doing with signing with a notary is totally not kosher, but how can we go after a firm?
After them in their individual capacity.
Yeah.
The other people who are mentioned, they're also subject to discipline. Practicing without a license.
So with respect to, let's bifurcate this out. With respect to the complaint before us and the allegations of unlicensed activity against this particular respondent, Earl made a motion to authorize a consent order with a $500 civil penalty. Is that correct?
That's correct.
Is there a second
Well,
And if the consent order is not accepted, then we would move forward in normal administrative proceeding.
I wonder if we should amend that to include the other two people who.
Well, I think we'd have to initiate our own separate complaint with respect to them. So with respect to this particular complaint, we can only deal with this respondent. And then once we're done with that, we can discuss if we want to ask them to open complaints and investigate with respect to the quote girls. Is that right?
Yes.
Okay. So is there a second of Earl's motion?
I second it.
Okay. Would the executive director call the roll, please?
Mr. Collins?
Aye.
Mr. Gibson?
Aye.
Judge Rambo?
Aye.
Miss Morgan?
Aye.
Mr. Mansfield?
Aye.
Mr. Houston?
Aye.
All right, thank you.
Okay, now on to the girls.
Can I ask a question about the previous one before we go on to the girls? Is it out of line for us to notify the bar associations and the judiciary within this court reporter's market area to alert them that she does not have a license? Because there's a good chance a lot of folks will never figure out that she is substituting a notary seal for a court reporter's seal. Lawyers and judges typically are not looking for that or thinking about that, especially if she has a very long history of having that license, and it will never occur to folks to look for that.
So, Judge Rambo, at this point, should this respondent agree and sign that consent order, the process here is to publish her name and the violation on the disciplinary action report. At this point, we would not put her name there because she has not agreed that she has, violated the law in any way, and we don't have an order to say that. But once that's done, that's how we notify the public of any action that the board has taken.
Another thought that I had too is
referring to that a discipline action is taken, but just that this person is unlicensed presently.
another thing we need to consider too is if this person only works in the criminal courts, they're not subject to licensure. So that would need to be cleared up as well.
Does the Bar Association get notice of these kind of things?
Unless they look at the disciplinary action report, we don't have a way to just send that to the Bar Association.
Well, I'll just use a contrast. If an attorney is suspended or disbarred, every judge in the state of Tennessee gets an email that says these are the attorneys who have been suspended or disbarred. And so we know they can't come in our courtroom and file pleadings and practice until they produce evidence to us that they've been reinstated. So at least the disciplinary board proactively notifies the folks who are dealing with them as part of the regulation of the practice of law. Seems like the attorneys, the judges that are dealing with the court reporters should receive some type of proactive notification that there's been a suspension or a disciplinary action that includes their inability to practice.
I understand what you're saying, Judge. I'll talk with Glenn about it, and we'll see if there's a way that we can try to make that happen. Just because it is in your authority to maintain a list of licensed reporters, and so that may be something that we can look into to see if that's something that we can make happen.
As food for thought, and I know that it's not a state entity, but the Tennessee Bar Association sends out the TBA Today email that goes to every one of its members, which I would assume would be almost every single attorney and judge in the state. And in the TBA Today email, there's a section where they they include disciplinary action taken against attorneys. Public censures, or suspensions, disbarments, etc. Perhaps there could be coordination there to include court reporter disciplinary actions, that we go ahead and just as an administrative process provide that information to the TBA. Now we can't make them included in their email, but I think it would be something, it would accomplish the goal that Judge Rambo is aiming at, and shouldn't be that difficult. And I would think that they would have interest in that, because it is of public concern, particularly for judges and lawyers.
Absolutely.
It's public information, so some of our potential customers and other licensed professions is so vast, so large. We just publish on the website because that would be the public at large. But the customers here are a very narrow, small pool. So I think we definitely can unpack that. I know Mr. Houston has another obligation. We do have quorum, if Mr. Houston, if you wanted to, if you need to meet that, or you, it's up to you. Just if you,
Yes, I would appreciate that.
Okay, sure.
And I apologize for being double booked today.
Thanks for coming.
Thank you.
It's good to see you.
I think we just had one more case, or anyway, on the legal report, and perhaps some new business.
Well, are we going to do something with the girls from this prior complaint? Do we want to do something?
Need a motion?
Yes, I think someone would have to make a motion that the board initiate a complaint and investigation against
The other main parties in this complaint.
well, they weren't named in the. We don't know what we don't know, so we don't know what type of information you all have on them, and we get into the anonymous complaint conundrum that we were talking about earlier. Any guidance from legal counsel about the best way to move forward on this, understanding that I think there's interest from the board in pursuing them?
And do you know did you have information on the other two, I guess, employees of this unlicensed person?
We do. I'd have to go back and just discuss it with the investigator. I mean, I start by just looking at the report. There may have been reference to specific names, but I would want to go back and verify that those people are still in the area.
So of course, I guess if we can figure out who those two people are, I think we can pursue an unlicensed activity complaint for them. I think the question at this point is, what do we do if we don't have their name? Do we go back to the respondent and see if she would give us a name? I don't know what incentive she would have to do that, because, like you said, she seems to be a pretty egregious actor. So I think that's what the board's discussing at this point.
Do I understand correctly that the court, that this person, the 84-year-old, is a criminal reporter?
No, it's my understanding that all these, when we refer to transcripts, that they're all civil cases. That's the impression that I got. That there were no reference to any criminal matters. No.
We would, if we take action, we would initiate a complaint and ask that an investigation be opened. The scope and lengths of the investigation would be up to the discretion of the investigator, as they always are, right?
Right.
How far he or she wants to go down the rabbit hole to try to investigate, not really our call.
Well, we always kind of give them general guidance, or we give them specific guidance. It just kind of depends on the case. Here, we could probably have the investigator get a little more specific. We know we're looking for a couple of people at least that are, we say the girl. Those people,
I
we
move
can find them.
that I make this motion that we move for an investigation, or I move that investigation be initiated for the two associated with the complaint that we just dealt with, and any other persons who are working under the auspices of that prior person that the investigator is able to identify.
Sufficiently specific for you all?
I think so.
Okay. Is there a second?
I'll second.
Okay, would the executive director call the roll, please?
Yes, sir. Mr. Collins?
Aye.
Mr. Gibson?
Aye.
Mr. Rambo? Or Judge Rambo? Ms. Morgan?
Aye.
Mr. Mansfield?
Aye.
Thank you. That looks like we have it's unanimous.
Thank you.
The next matter for represent is 2016-03. This was a complaint filed against a court reporter that was working on an expired license. This matter actually was transferred over to us from the AOC when we were given the jurisdiction to have the Board of Court Reporters under the Department of Commerce and Insurance. The complainant said that he or she was advised by the Hamilton County Circuit Court staff that the respondent was performing court reporting services, and the complainant was under the impression that this individual had moved because the complainant was approached by the respondent and asked what was involved in transferring a license to another state. When the complainant learned that this individual was practicing in Hamilton County, he or she contacted the respondent and to find out what the status was of the license, and that person was still an expired license, still in expired status, and had not done anything to renew the license or bring it to current status. So the board had voted to authorize a formal hearing and assessed a civil penalty in the amount of $200 practice. So when this matter was transferred to our office, I immediately began the formal hearing process and drafted the notice of hearing and charges, and we were ready to serve that on the respondent. Well, it turned out we couldn't locate the respondent. So then we accessed our databases to find out where this respondent might have moved to, and we still could not find them, and then finally did find them, and then had this notice of hearing and charges reserved on the respondent. And it came back to us as undeliverable, and that respondent was not at that location. So we checked again and could not find any updated address. Kind of at an impasse in this situation because we can't serve that notice of hearing and charges. So my new recommendation is to close this in light of that, as well as the age of the matter, meaning it was transferred from Administrative Office of Courts, and it's probably a 2015 or 16 case.
One question I have about this is it's in circuit court. Was this a civil matter or was it a criminal matter?
Court reporting?
Did the reporter report a criminal case or a civil case?
I believe it was a civil case.
Okay.
There was a definite violation. Our problem is that we cannot find this respondent to serve them the notice of hearing and charges.
The updated address, the one that you're most recently getting undeliverables on, is that in Tennessee or outside of Tennessee?
I believe it's out of state.
All right, this one is old. I'm just kind of spinning our wheels on it at this point.
Judge, you may want to put your phone on mute. Sorry, just some background filter noise we were hearing. Go ahead, Chair. Apologize.
That's okay.
I'll make a motion that we close this case.
Is there a second?
Is there anywhere that names can be disclosed, such as Mr. Collins suggested, so people don't call this person for depositions or?
Well, there's some due process concerns. I mean, she has not been found to have violated the rules and regulations. So, I mean, if we publish information that she's engaging in unlicensed activity when she's not been found by any competent body to have actually engaged in unlicensed activity, then we're all going to get sued for slander. Some enterprising lawyer.
I personally don't think we should close it because the complainants have not withdrawn their complaint, have they?
No, not to my knowledge. I have not been in touch with the complainant, but they have not withdrawn their complaint. And I believe the complainant is a licensed court reporter in Tennessee.
So it's just a problem of service for the respondent.
Yes, sir.
I don't feel like we should just close the case for such an egregious.
Can it be closed without prejudice to be reopened if we ever find her?
Yes, we can, in the system, I believe, close and flag that if this individual applies again, Glenn? Yes, they were. Yes, we can do that in our regulatory licensing system to flag them that should they reapply in Tennessee, they would have to more than likely appear before this body to. Yes.
Yes,
I would like to amend my motion to close this without prejudice.
I'll second that motion.
Will the executive director call the roll, please?
Sure. Mr. Collins?
Aye.
Mr. Gibson?
Aye.
Judge Rambo?
Aye.
Ms. Morgan?
Aye.
Mr. Mansfield?
Aye.
Thank you. That's unanimous. My roll call vote.
Thank you.
Thank you.
Okay, that looks like that was it for the legal report. The next portion was the legislative updates.
So I think the only thing to update the board on is the Fresh Start Act that passed this past session, went into effect July 1st. And essentially what that law requires is that if a new applicant lists any felony conviction on his or her record, prior to the board denying that, there's a list of factors that the board has to consider, such as I'm sorry, I got distracted. I apologize for that. So the board has to consider like 5 factors: the length of time since the conviction, the person's character, the relationship between the conviction and the license that he or she is seeking, and any character references or rehabilitation evidence that they may present. And so those have to be considered prior to denying an application for a criminal conviction. That doesn't affect any other reason that we may deny it, lack of education or experience or anything like that. It just goes strictly to the conviction. I'm not sure that we've had that issue come up with applicants in this particular board, but I did want to make the board aware of that because there's a process to go through when and if that situation arises.
But is that we don't ordinarily get involved in approval or disapproval of extra license applications. So what you're saying is in those instances we would, does that review have to be done by the actual board or does it remain just an administrative process?
So I would say that yes, it does need to be reviewed by the board because the board has to look at those factors and determine if that conviction warrants denial of that application.
Basically creating one additional, kind of what you're alluding to, creating one extra layer of administrative hurdle if we were to deny someone.
Yeah, I don't have any problem with it. I'm just curious because it's not like when people apply to the board that it comes before us and we review their application and we, as a body, say yes or no. Administrative staff does that, and then I guess somebody could appeal a denial as an administrative matter if they want.
And that remains the same. Like I said, if we get something, and I think from my limited experience, like I said, this went into effect in July. I think the biggest connection for the legislature is the conviction, the length of time since the conviction, as well as the conviction as it relates to that regulated profession. So they don't want, I think they want to give the public the opportunity to become licensed in whatever field they seek, but they don't want to let a 1990 conviction that has nothing to do with this profession that they're trying to get into stop them from attempting to work.
Good luck.
I think that's the only legislative update I have for you all.
That was the end of our agenda, so we're at the new business portion. So unless there's anything else, feel free to jump in there as far as new business goes. But that's all we had on our end of the table.
Anybody have any new business? Okay, there being none, is there a motion to adjourn the meeting?
Make a motion, we adjourn.
Second.
Okay, Executive Director, call the roll, please.
Sir. Mr. Collins?
Aye.
Mr. Gibson?
Aye.
Judge Rambo?
Aye.
Miss Morgan?
Aye.
And Mr. Mansfield?
Aye.
Thank you. That is unanimous.
Okay, we will adjourn at 10:11 a.m. Thank you.
Thank you, Chair.
Thank you, Judge Rambo.
Good job, Rick.
I think that was my last one, right?
You know what? No.